of Tennessee is now in session.
Afternoon, and welcome to the afternoon session of the Court of Appeals. Your panel today will consist of Judge McGee, Judge Armstrong, and I'm Judge Golden. Madam Clerk, will you please call the next case?
Luna Law Group, PLLC versus Richardson M. Roberts.
We'll hear from the appellant.
Thank you, Judge Golden. Jim Kay of the Nashville Bar. I'm borrowing a conference room in Chattanooga right now, so I'm a little out of the elements, and then I'm getting some flashes on the screens I may have to click off of. It's a pleasure to be before the court today. My client.
I understand you're not reserving any rebuttal. Is that correct?
That is correct, sir.
All right, you may proceed.
Thank you. My client is a well-known Nashville businessman who had faced a significant legal problem in 2007 when he built a dam on his farm just west of town at the Bucksnort exit. The state came in and the feds came in, and he had a significant legal problem to the tune of $37,500 per day under the Clean Water Act, totaling $124 million in fines potentially, and potentially a criminal indictment. He went to what he thought was the best, a high-powered team. And I say team because in spelling team, there's no I in the word team. High-profile case, and he found Mr. Luna and his firm. He needed a leader, a captain of the ship, a quarterback, a general in charge of the command that put his interests first, that would tell him the truth and earn a fee that was charged. He signed an engagement letter, which is before the court, and it was billed monthly, not in the engagement letter that it was due on receipt, but Mr. Luna testified that that was the deal. And what he got in return was 4.5 years with the Luna Law Firm. He got a bill every month but one, paid most of them in a timely fashion, but not all. But he got dysfunction, a law firm that split up within 2 years. His complaints were ignored. He had partners in these two firms that would not work together. There was no management. He did not get to know what was behind the curtain and what was going on with the lawyers. He got billed $839,000 in fees by the Luna Law Group, $363,000 in expenses. And then he had to go to another firm that ended up salvaging the case, prepared it for trial twice, and only spent $528,000 in legal fees. He went to a team at Bill Farmer and Will Hawkins. This was the team that won the game and got him an excellent settlement in the federal court with the help of a law professor that they had to be hired. The engagement letter here is the pillar of the case. We contend that it's severable. The other side and the chancellor agreed with the other side that it was not. If you look at the engagement letter, $10,000 was going to be kept in trust monthly. It was going to invoice monthly with monthly billing statements payable on receipt, as Mr. Luna testified in the record at page 1047. The $10,000 applies if you look in the engagement letter, even after it's going to be applied to the last month's bill. That's important because our contention is this is severable. The chancellor concluded, not only the first chancellor, Chancellor Bonnyman, but we made a crack at getting her first ruling reviewed by Chancellor Moskal. And Chancellor Moskal agreed with Chancellor Bonnyman that this is not a severable contract. We believe that it is, that the deal was not only in the contract, but in the course of dealing and with Mr. Luna's testimony, that the obligation to pay the consideration only comes when you get a bill every month, kind of like NES or Piedmont Gas or any other utility. And that the statute of limitations on each bill would begin when it was supposed to be due on receipt. The chancellor saw it differently and believed that in applying the Murray case, that the statute of limitations only runs when the lawyer is no longer on the matter. So therefore, Mr. Luna filed while within the 6-year statute of limitations, and therefore our defense was crushed before our eyes. We're asking the court to take another look at this. And I go like the old Senator Howard Baker. I always listen to the other. Senator Baker's comment was, always listen to the other guy because he may be right. Every time this has been looked at in the Chancery Court, we've been told we've been wrong. This is our last time. You may tell us we're wrong, but our contention is that this is severable and that Mr. Luna consequently missed the 6-year statute of limitations on each of the invoices which are at play that covered the $136,000 judgment.
Okay. You argued earlier that the agreement was that the monthly invoicing was to be paid upon receipt. I've looked at the engagement letter. I don't see that provision in it.
And Judge Armstrong, you're correct. It's not in the engagement letter, but it's on the record 61, page 1097, where Mr. Luna acknowledged on the stand that they were due upon receipt. And that had been the course of dealing with the client as well. There wasn't any misunderstanding about this. Hey, you get a bill and it's due. That's not exactly what the engagement letter says, but that was the deal. And everybody knew that. We believe, Judge Armstrong, Judge Golden, Judge McGee, that the court should have taken a look at the Cohen case, where another panel of this court on a previous matter ruled that one of the bills was within the statute of limitations and the other one was out. We think our facts are even better for us than the Cohen case. We've got more compelling facts, and simply put, it's either severable or it's not. If it's severable, Mr. Luna has missed the statute of limitations on every single bill that is in dispute in the case. However, if the court feels differently from what I'm arguing, and the court, there are other ways that this case can end. I can't believe that after 37 years of practicing law, I'm here arguing gross latches. It's interesting that the trial court denied the Luna Law Firm request for prejudgment interest based in part in the opinion on gross latches. Our position is the gross latches should have applied to the entire case. He's a lawyer, sophisticated, did nothing from end of 2011. 2012 goes by, 13, 14, 15, 16, not a peep, while he's holding $10,000 of money of the client in his trust account, and then hits the button to fire his lawsuit in 2017. It is very true that we did not lose any witnesses. That's part of one of the gross latches overview of this. But every single witness at this trial couldn't remember many things. The transcript is loaded with, I don't remember, I don't know. I'm paraphrasing here. Gee, I've lost that one. over and over and over again. And we believe that affected whose memories are good. You know, from my standpoint, I can't remember what I did yesterday, much less 3 years ago, 5 years, or 7 years ago. And it affected the memories, and it affected the proof. If the court doesn't like that, look at the fees. Look at the block billing. Page 42 of our brief is a block billing where Mr. Luna charged the client for complaining about another lawyer's performance in the case. The block billing is atrocious. But most importantly, the one lawyer in the case that testified was our expert, Bob Boston from Waller here in Nashville, who is the only lawyer in the case that is a member of the American Trial College. It's the ultimate award as a trial lawyer in the state. And he testified that Mr. Luna was not the captain of the ship. Every team needs a captain of the ship. And when you don't have one, you have problems that make the fees go up. And in this case, not only were they huge, they were unreasonable. Just like every great army has a great general, every great team has a captain, every great football team has got a great quarterback. Mr. Luna, under the engagement letter, took on that role, that he was the lead man. We quoted in our brief a very telling statement from Mr. Luna during the trial, where I asked him from January 2011 through April of 2011, could he tell me who was in charge of the case? And he said, I don't know. Mr. Luna as well did not tell his client that one of his partners had a serious mental health problem and had to check himself into the Vanderbilt psychiatric unit. I know we don't need to disparage what happens to people on their health wise. This man, Mike Peregrine, is a great lawyer. He was the brains behind this. And according to Will Hawkins, who was an associate with Bill Farmer at their new firm, simply disappeared when responses to motions for summary judgment were due. The most critical time of the case in terms of preparation, and the lead brains behind the case, and everybody knew it, and it was clear in the trial record, disappeared. The client didn't know, nor did the team of litigators with Pharma at Bill Farmer's firm when that happened. And it was a near disaster. Will Hawkins was able to get Steve Shepard, a law school professor, in to help with these. Other than if that hadn't happened and he did it on his own accord and saved the ship from sinking, this ship would have gone down on summary judgment.
Mr. Kay, isn't it true that Hawkins hired Shepard months before Mr. Peregrine went into the hospital, and he brought him on because the trial lawyers apparently didn't work well with Peregrine, and they decided they wanted to use a law professor to do that work in terms of responding to the motion for summary judgment. Mr. Peregrine was never going to respond to the motion for summary judgment, as I understand from looking at the trial court's findings.
It is true that the billing records show that he talked to Mr. Shepard earlier than his recollection and testimony at trial. Nevertheless, this is a key player and the key player behind the curtain in the case disappeared. And that is something that you tell your client if you're the lawyer on the case. We've got a problem. We've got to get somebody in. We've got deadlines coming. We've got to address this, and we've got to address it now. You don't not tell them. And one more statement in here, if it pleases the panel. The email in our brief from Mr. Luna to Mr. Farmer sums everything up. We got this in discovery, had no idea of what was going on behind the curtains. The client was complaining over years of time about what he was getting charged for and the problems that the team was giving him. And on page 42 of our brief, Mr. Luna, in an email to Mr. Mr. Farmer, says, I'm not going to tell, it's not on page 42, I'm sorry. I'm not going to go through the history, and I'm not going to tell the client because it will invite questions I will not answer. That sums up what was going on behind the curtain. Thank you.
Thank you, sir. All right, we'll hear from the appellee.
Good afternoon, Your Honor. I'm Horton Frank of the Nashville Bar, and I represent the Luna Law Group. This is an appeal of a judgment of the trial court awarding judgment to the Luna Law Group against Rich Roberts for $126,283.23, together with the $10,000 retainer that the firm continued to hold. The facts are found in great detail in the court's memorandum opinion. In fact, the first 18 pages of a 29-page opinion are those findings of fact. And I'll digress for a moment to point out for the panel that, interestingly, virtually nothing that Mr. Kay said to summarize his client's views of the facts found their way into the chancellor's findings of fact. I won't go into those in detail, but that said, it's important to take a look at this. The trial court heard 2 full days of testimony from 6 witnesses and admitted 50 exhibits into evidence, including all of the invoices of the Luna Law Group from day 1 forward. She prepared a 29-page memorandum opinion and final judgment, and she made detailed findings of fact and conclusions of law. She correctly applied well-established rules of law and legal authorities, which are articulated in the opinion. Her findings of fact are entitled to, or come to this court with a presumption that they are correct unless the preponderance of the evidence is to the contrary. Her determination about the reasonableness of the legal fees charged by Luna Law Group are reviewed by this court for an abuse of discretion, and there appears none. Her determination of the credibility of the witnesses, including Mr. Boston, is entitled to weight by this court because she was there to observe the demeanor of those witnesses. Mr. Roberts offers nothing in his brief in the way to demonstrate that the preponderance of the evidence is other than what the chancellor found, and nothing in the brief to suggest that her findings with respect to the application of the section 1.5 factors to determine the reasonableness of the fee was an abuse of her discretion. Mr. Roberts simply reiterates the same arguments that he made at trial and the same arguments in his pretrial brief. For those reasons alone, the court should affirm the judgment of the trial court. The first issue before the court is Mr. Roberts' claim that Mr. Luna's complaint is barred by the applicable statute of limitations, which is in 28-3-109. Mr. Roberts filed a motion for summary judgment near the outset of the case, claiming that there was a separate cause of action for each of the 52 invoices sent to him by the Luna Law Group. He claimed that a separate cause of action accrued with respect to each of those 52 invoices, and that a complaint filed on July 5, 2017 was time barred. It's more than 6 years after the last invoice was sent. The Luna Law Group opposed the motion, claiming that the engagement letter agreement was an entire one, and that the cause of action accrued not when each individual invoice was sent, but when the services were completed or terminated. The trial court denied the motion for summary judgment and found that the engagement letter agreement was in fact entire, because the services were continuous and indeterminate in their duration. And it's very significant that the trial court focused on the services and not on the invoices, because that's where the focus should be. Mr. Roberts asked the trial court to alter or amend this order shortly before trial, and the court denied. And at the conclusion of proof, Mr. Roberts asked the court again to dismiss the complaint on the grounds of the statute of limitations, and for the third time, the court denied it. The court should affirm the three rulings of the trial court because the complaint is not time barred. The trial court correctly found that the agreement was entire and not severable. The agreement's entire because the promise to render services is an obligation that is continuous and indeterminate in duration. And as trial lawyers, we all understand why. The promise to render services and the promise to pay for those services are interdependent, and they relate to the same subject matter. The enforcement actions, 7 or 8 of them arising from the building of this dam and the impounding of the waters on Mr. Roberts' land without a permit. The court should reject Mr. Roberts' argument that the engagement letter agreement is severable into 52 causes of action. The court should reject this argument because the argument advanced by Mr. Roberts relies and focuses on the invoices and not on the services. All of the legal authorities, principally the Murray case and in re State of McClanahan, and the cases that are cited in each of those opinions, focus not on payment, but rather focus on the nature of the services and their relatedness to a single subject matter. Moreover, the legal services that are rendered by the firm are not taken out of this rule because there are invoices or periodic payments made while the services are being rendered. The court in Murray versus Grissom cited to a statement of this rule in Williston on contracts, and the citation is critical, and it reads as follows. And the general view is that though in an entire contract for continuous indeterminate services, there is a stated or customary time of periodic payments, the statute is not put into operation from such periodic dates, but only from termination of the employment. And that in sum and substance takes care of the statute of limitations, because the agreement, as the trial court found, 2 different chancellors, is clearly entire and not severable. And therefore, the cause of action, as the trial court determined, did not accrue until July 12, 2011 at the earliest, and at the latest October 12 of 2011, when an order granting the Luna Law Group leave to withdraw was entered. Mr. Roberts next claims that the fees were excessive. And the trial court devoted considerable discussion to this and properly applied the Rule 1.5 factors from the Code of Professional Responsibility. It was unrebutted that it was a complex and difficult matter. The trial court said extremely complex scientific, legal, and technological environmental issues governed by an unsettled body of law. The court found that it was again unrebutted that the legal services required the Luna Law Group to defend Mr. Roberts against some 7 or 8 different enforcement actions brought for both civil and criminal penalties. The court found that it was unrebutted that the hourly rates were reasonable and weren't raised over 4.5 years of the representation. It was found, and it was unrebutted, that Mr. Luna and Mr. Peregrine had substantial expertise and experience in environmental matters, and they were highly respected for their expertise in the community. It was unrebutted that it was a high stakes case. There was tons on the line for Mr. Roberts, and Mr. K recognized that at the opening of his argument. The defendant, however, contends that credit for the result belonged to Mr. Farmer and Mr. Hawkins and not to Mr. Luna and Mr. Perrigan. But the court addressed that and very specifically found that both firms contributed to the good outcome and that it required the expertise and skills and talents of all four lawyers to achieve that outcome. This court should therefore affirm the finding of the trial court that the fees are reasonable based upon the application of the section 1.5 factors. But Mr. Roberts argues nonetheless, based upon Mr. Boston's testimony, that there has to be a captain of the ship or the fees are going to be excessive or unreasonable. Interestingly, the trial court looked at Mr. Boston's testimony and said he didn't cite a single time entry that he claimed was excessive, and he was unable to give an opinion on the aggregate amount of the fees that were excessive or unreasonable. So you won't find any finding in the trial court's 29-page memorandum opinion that's based even in part on Mr. Boston's testimony, because she didn't give it the weight that Mr. Kay and Mr. Roberts gave him. And as a result, that should be disregarded as well because of the weight accorded to the trial court's finding on the credibility of an expert witness. The next item the court found, Your Honor, and it deals with the Cohen case. The Cohen case is clearly distinguishable from this case because the Cohen case, as Justice Armstrong asked earlier, includes a provision that provides a specific due date and pre-judgment interest on unpaid balances. That doesn't exist in the engagement letter agreement. And I invite the court to look back at the transcript, because there isn't the testimony that, excuse me, Your Honor, I lost my train of thought. There isn't the testimony that Mr. Kay argues there is, that there was an agreement that the fees would be paid upon receipt. And the fact of the matter is, if the court looks at Exhibit 5, what you'll find is the payment on an invoice by invoice basis for the first handful of the 52 invoices. And then after that, there are just simply periodic payments that are applied to the oldest invoice coming forward. And there's a chart laid out in the interrogatory answer that was admitted into evidence that clearly lays that out. The Mr. Roberts next contends or claims that the fee should be disallowed or found to be unreasonable because of block billing by the attorneys. Block billing is a practice of including a lot of time entries in a single large entry on a billing statement. I'm not aware of any Tennessee case that looks that deals with the propriety of block billing, but there are a lot of federal cases, and some of them are cited in the Luna Law Group's brief. But the end result is there's no problem with block billing if the court can look at the time entry and determine what tasks were performed so that a determination of reasonableness can be made. And that's exactly what Chancellor Moscow did. And what she held was, I have no problem with the time entries because I can determine the complex and difficult tasks that were performed. Your Honor, the court denied the request in the complaint for prejudgment interest, and Luna Law Group takes no issue with that finding on this appeal. But the existence or the potential for prejudgment interest was the only basis for a claim of lashes. And that's why the trial court did not award them, because the trial court denied the claim for prejudgment interest. There was no loss of a witness. There was no loss of a document. While people 4 or 5 years after the fact sometimes struggled with their memories, I submit that can be found in the testimony of lay witnesses in almost any kind of case. But six witnesses testified over 2 full days of trial, and at the end of the day, they provided enough recollection of facts in order to generate the chancellor's memorandum opinion. Your Honor, I respectfully submit that the court correctly decided and articulated in a very fair and reasonable manner the findings of fact and conclusions of law that sustain this judgment, and that the briefs of the appellant simply re-argue the same points but do not establish a preponderance of the evidence to the contrary of any of the findings of fact or that Chancellor Moscow abused her discretion. I would therefore ask on behalf of Luna that the court affirm the judgment of the trial court and remand the case for enforcement of the judgment. Thank
Thank you,
you.
Mr. Horton. Thank you both for your
Mr.
argument
Frank.
today. Any questions? I did- I
No,
was saying-
my last name is Frank.
Oh, I'm sorry.
That's all right.
Frank.
You-
I'm sorry. I beg your pardon, Mr. Frank. I just said thank you for your argument today.
Thank you, sir.
All right. We'll now adjourn. If there's no questions, we'll adjourn till the calling of the next case. Thank you.
This
Thank you, Your
Honorable
Honor.
Court of Appeals is in recess until 3 p.m.